Welcome back again. This is Carl Weiss at Fairway Independent Mortgage Corporation. My NMLS number is 263293, and we are joined today with Heidi Thompson, who is an estate planning attorney in Arizona, and we are diving deep onto some estate planning topics. And right now we are diving a little deeper into the trust world and probate avoidance. And so we've talked briefly about that the trust itself is a document written by yourself that lasts presumably forever, well past your lifetime, and that items, I guess we'd say properly, Heidi, correct me if I'm wrong, that are funded into the trust, then by very nature avoid probate.
Correct.
So walk us through that side again. I mean, I think we've talked, at a fairly good length about, maybe why we would want to avoid probate, but I think just from the simple thing of adulting where you say, hey, I have this stuff, I want it to go to these people, and I don't want to wrap that up in a hassle. This shouldn't be a complex thing that I leave for them to sort of figure out and navigate. They'll have enough other things to consume, I mean, personally, like just emptying my house would be its own full-time job, right? I don't need to then put you through paperwork, send you to attorneys and courts and have you figure out if you're really the rightful heir.
Exactly. Well, and regardless of whether you're choosing a will-based plan or a trust-based plan, either way, if it's well written by an attorney, it'll provide good instructions to the person who's supposed to take over for you with what they're supposed to do after you're dead. So I'm really not, as far as that part of it, where your things should go and how they should go, trust versus will, either one of them will work for that. The point is, if you're doing the will-based planning, the asset planning around it is that you're looking for everything to automatically go to beneficiaries. So it's really not going under the will. The will is just describing where it goes. Under
Okay.
the trust, on the other hand, everything is going under the trust. We're actually titling it in the trust so that it stays there and can be distributed from there, which is why it doesn't go to probate court. It's all
Okay.
owned by the trust. You can kind of think of like when a business owns inventory, it's owned by that business, not the manager. Same thing with the trust. The trust is going to be titled for the assets. You still are the one that benefits from them during your lifetime, and then someone else benefits when you're gone. So that's a kind of an interesting way to think about that.
And so in the trust itself, obviously, on that continuum where a will may be, less paperwork, less involved, less expensive, the trust then comparatively is going to be, a bigger, beefier item that's going to,
A lot more
be
drafting.
more drafting, cost more upfront, but should alleviate quite a bit of concern. Now, do you have to have $100 million? Because, most people hear the word trust and they're like, well, my name isn't Rockefeller. Maybe I don't need a trust.
Well, and I would say, I'm probably in my business right now, 70% trust, 30% will-based planning.
Okay.
I still have plenty of people who I call it the reliable Honda plan. And if they do the good asset planning, they don't have $75,000 worth of stuff in their house, we can get away with the reliable Honda will-based plan. But for anyone who wants some bells and whistles, now we only talked about probate avoidance, which is one of the bells and whistles, but let's think about this like a custom BMW. Maybe you want the power windows and the power seats and the power rooftop, and you want, the heated and massage chair and all those kinds of things. A trust kind of offers all of that, where a will really doesn't. A will is just what we think it is. It's that letter to the probate court. Here's where my stuff goes. Here's where my kids should go. Here's where my pets should go. That's it. The trust is so much more than that. A trust is, this is how I want to be managed if I'm incapacitated. A trust is, this is the $10,000 I'm leaving to take care of my dog, and this is how it should be distributed based on that care. And here's how my kids are going to grow up. Here's what we're going to provide for them when they're under 18. Here's how we're going to provide for their college. This is what they can or can't major in. This this is, when we might buy them a car, and this is, and all the way through. And if you've got adult kids and you're not maybe 100% on board with them receiving an outright distribution. We can distribute over time under a trust, which we cannot do under a will. We can even get really clever with some of that, and that's sometimes my favorite planning. So,
Yeah, and I think that's great, and, I think the other part of that is, how it happens, when it happens, those bells and whistles can be very intricate, right?
mhm,
On the trust side, whereas, the will is, it's one of those, it's sort of, my experience personally, when my father died a couple of years ago, he had a will, and I ran into and he was just too cheap, really to get a trust, and he really didn't think he needed one, and in a lot of respects, he's probably correct. However, there's things in a will that are written where you sort of get the spirit of the law and you know part of it, but you don't get the actual detail part right.
that's it.
And so you get the letter of the law part, but the spirit was like sort of forgotten. So like, for me personally, my stepmother had a thing where my dad wrote in the will. He said, "Hey, um my wife can have her pick of the jewelry, and whatever she doesn't want, goes to my son." Great. Seems pretty fair, except that she took it all, right? So, having a will, you go, well, that wasn't his intent. That wasn't really what he had in mind. He just thought he would leave it up a little bit up to chance, and that, he thought, oh, she'll do the right thing in his mind.
Remember when in our first episode together, you said that you liked the fact that we talked about we do more counseling than I use
Mhm.
the counseling degree more than the law degree.
Absolutely.
This would be a perfect example of that. So if I were sitting doing this planning with a client and he said, I want my wife to have the jewelry she wants and then everything else goes to my son, I would ask specifically, do you mean that if she wanted to keep all of it, she could? As a follow-up question, I would ask that just
Right.
naturally. And if he said no, I would just want her to pick a few things. Then I would say, then why don't we say she can pick 5 pieces of jewelry she
Right.
wants to keep and the remainder goes to my son. And see, this is the, there's kind of the science of estate planning and then there's kind of the art of estate planning. And
Right.
I would say some of this is the art of estate planning. Not every attorney you sit with is going to ask those follow-up questions to do the details.
That makes
Um,
total sense. And I think that, we live in a world where like every answer is at our fingertips, right? So you can find these forms, you can go download, you can be both, a self-prescribed attorney and, doctor all in the same day, right? You can go to WebMD and come up with all kinds of stuff. And I think that, more than ever, this is that time where, when you're really looking to look at estate planning, you have to pick someone who really understands and can help you navigate the waters. And they may seem calm today, but my experience is that when somebody dies, the waters get really choppy. And that's when the problems start. They don't start sitting around the table at your office.
and it's not always the items of value. I tell the story in my book that I learned from another attorney. It was not my case, but it was such an interesting story of a family that traveled with 5 kids to Hawaii. And it was the only, when you have 5 kids, you don't take a lot of trips, right? So
So
this was a
true.
big trip for their family. And the mom during this trip went to one of those ABC stores and got this little dancing monkey. I'm sure we've all seen the little hula monkeys. Well, the mom made a big deal at the dinner table with the kids when she was celebrating the kids growing up that the dancing monkey would sit at your plate if you had a good report card or something interesting that you were being celebrated for. So when mom dies, the kids all start fighting over this little $3 dancing monkey, which incidentally you can still buy for, under $10 in Hawaii. They could still buy the same thing, but no, they wanted this one. So
Right.
all 5 kids got their own lawyers. They wasted hundreds of thousands of dollars fighting over this little plastic dancing hula monkey.
Mhm.
Um, they all thought that they should have it. Um,
That's
it's
incredible.
it's a fascinating story, and it just goes to show
Mhm.
it's not always rational and it's not always the things of value. It's the things that mean something in the family, especially if there's an item that defined a person. For my grandmother, she was a seamstress. All 3 of her daughters wanted her sewing machine.
Right.
right?
Yep.
For the dad who was in a rock band in his 20s, his guitar that, he used all the time, all the kids are going to want that one. The, the mom all the kids are going to want mom's wedding ring,
Yep.
especially the girls. Um, there's just going to be things. Dad's Rolex, if there is one, the
Yep.
boys are all going to want, and the girls probably will too. So it's,
Right.
um, it- and then the other things you don't think about too is the family heirloom kinds of things. Let's say grandpa wrote to grandma in World War II or something like that, or,
Mhm.
you know, those are also only one person can have them.
Right.
Those are the kinds of decisions you really need to put in writing.
Yeah, and I don't even know on some of those things, right? It's like, well, they don't have a beneficiary designation on it, right?
They
So
don't.
who
So you
comes
have
to the
to,
number, it has to be listed out, right? It has to
it has
be
to be listed
right.
out.
Yeah.
Yes.
And is that something that, obviously when we talk about bells and whistles of a trust, that those things could go into a trust very simply.
And honestly, those can go will or trust,
Okay.
depending on the attorney you're working with. Regardless of which way I'm doing, if people have things that they've already thought about, I will put them in a will or a trust, like those kinds of things. And then either one references a personal property memo where they can hand write those kinds of things and sign and date it, that's
Okay.
attached to their estate plan and incorporated by reference. So those kinds of things they can do later. But I'll tell you, just human nature. Once you get back the estate plan after you've gone through the process, human nature is you put it on the shelf and you're never going to fill out a form again.
Yep.
So whatever we didn't do in the process actively together probably isn't getting done unless something in your life happens that says, oh yeah, I need to do that.
Correct. Yep. I've been there personally. Yes. So true. It's a great paperweight if you're not careful.
Yes. Yes.
So we've talked a little bit then, in terms of the trust itself, and you know, we haven't gone too deep yet into the taxation of an estate, right? And so I think maybe that's something we can hit at a different segment, but there might be reasons that we want where, it sounds like, broad brush strokes. When you have a will and everything is distributed, it's done, it's over, right? And in the trust, when we title things and we put things inside of the trust, that trust lives on and remains, and those items are sort of the property of the trust. And there might be some other reasons to have that trust, depending on the estate itself, right? Where it could, relate both to the taxation and the inheritance tax and things along those natures, I assume. Is that fair?
What we can, it, we probably need a separate segment for that section
Okay.
because the tax is its own topic for sure. But I don't mind talking about it. Um,
And do we,
Suffice it to say,
is that a good summary though, to say that it might be a good reason because of those other bells and whistles, and one of those bells and whistles of the trust could be there could be some reasons that you want to do that relate to taxation or
there can definitely and absolutely there can be some good reasons to include some tax planning and trusts, but it's not for everybody. So
okay.
we will delve a little deeply into that. But yes, tax planning can definitely be a part of it.
Okay. What other topics on the trust are worth hitting now in terms of why we might pick a trust over a will?
Okay, let's talk about incapacity.
Great. I love that
So
in the book. Yeah. By the way, Heidi's book is fantastic. Let me put it here so people can actually see it. Um, but yeah, there's a great section. In fact, I love that when you're talking about the jellyfish, right? Um, and so yeah, please jump into that and let's dig deep on incapacity because I think that's a really underplayed topic.
it is. People think they need an estate plan for death. Honestly, in all of this world, at least from my side, death is easier than incapacity.
Mhm.
Um, Death, the rules are very clean cut. Incapacity, things get really messy really fast. Think about it. Let's say you did your first estate plan when you were in the military and you were 23 years old. And now you're 50 years old and you've never changed your estate plan. Well, chances are you made your parents your power of attorney. They might be getting a little old to do that and your wife probably wouldn't appreciate it.
Right. If they're
Um,
still alive. Yeah.
if they're still alive at
Yeah.
all, right? Um, Power of attorney is an interesting thing. A power of attorney for finances, they often call it a durable general power of attorney. Durable, it lasts. General, we're giving them lots of things they can control in your life related to finances. This is your legal person that if your doctor certifies that you can no longer manage your personal and financial affairs, just a doctor's write-up that that's the case, then the people that you appointed take over and start managing your finances for you. It can happen a couple other ways, but that's the most common. Um,
And so in that respect, they get to pay your bills.
they pay your bills, they can contract for you, they can sell a house, they and then move you into an appropriate facility if needed. They can bring in around the clock care if needed. They can pay for all of your ongoing expenses. They have authority over investments. They can shut down your Facebook account. You don't even think about those kinds of things, but
Right.
those are
Mhm.
all pieces. Clean up your credit report that it shouldn't be used for, blah, blah. There's just a bunch of things that they need to be able to do during incapacity, and it's tough. The problem is if you did your power of attorney a long time ago, and now this person that's going to work for you walks into Chase Bank and sits down at the teller and says, I need to be able to access these funds. Here's the power of attorney. Well, sir, that was written 20 years ago. How do we know that's the current one? Do you see where the problem might arise?
Yeah.
I mean, I don't blame the banks for that. How do they know that's the current one? How do we know you didn't pick one that was 3 power of attorneys ago?
Right. And what's the appropriate amount of time in terms of age? How old could it be until they ask that question?
And unfortunately, it's not black letter law. It's
Right.
a little bit messy when we get into where bank policy and law overlap.
Right.
In general, if it's 3 years old, you're probably okay. If it's 5 years old, you might be. 10, it's not.
Okay.
And
So
that's
it's
not a
a
hard and
lot of
fast
gray
answer.
between white and black.
Right. So having said all of that, sometimes if we are doing will-based planning, I'll actually advise the clients to do something a little bit sneaky. And I'll tell them to go to their bank now while they have capacity, put the person's name down that's going to be power of attorney as if they have authority now, but not tell that person. So
Mm,
that when that person takes the form to the bank's going to say, oh, yeah, we already have you on file.
nice.
Problem solved. It's a little bit of a sneaky workaround, but that's kind of what I do. Now, here's the beauty
And
of
they
a
can
trust.
just add them as an account holder at that point.
Well, they're not an account holder. They're power of attorney, meaning they're an agent acting for you. Every
Okay.
dollar that they use is supposed to be for your benefit. If they do it for their own, they can be subject to criminal prosecution. They'll, they can lose their right to inherit, fees, costs, double repayment of any dollar they spend on themselves. It's a big deal. You don't
Okay.
take advantage of an incapacitated person in Arizona. It's
Okay.
not a thing to do. Now,
Great.
under a trust, it's entirely different. And this is where I think trust, it's another really good selling point for a trust, is your successor trustees listed in your trust are already on file with the bank when you put that account in your trust because you gave them the trust certificate that has the successor trustees already on it.
Even if
So
it's
they
10 years old.
so even if it's 10 years old, they already have your trust information.
Okay.
So all that person's going to have to do is bring in the letter of incapacity to the bank and say, I know I'm already on file as the trustee. I'm going to be the one that's doing the trustee work from here on out. And they'll probably get a signature card, but that's it. You're still, if the person's alive, you're still acting as an agent for them. All
Right.
that still applies,
Okay.
but it's a little cleaner and easier. There isn't really a time limit on it when it's in a trust.
Nice.
Yeah, it is nice.
Well, and that it ties into something I was going to ask you later, in a different segment of when we talk about, updating documents, right? I mean, that's a thing we do in life, and we don't necessarily know upfront how long, you take a trust, right? It lasts forever. Well, does it?
Yes,
It does
it
until
does.
there's a state law change or, potentially some other guidance, so sometimes things change personally, and then some things change law-wise, and it's worth, going back and just double checking, is this the most current document? and sort of is it believable, right?
Yeah, and we can definitely talk about what those are in that segment. I think that'll be a
Okay,
good one too. So there's a couple key
cool.
changes that have happened throughout history that are worth chatting about. So
Great. Okay, so we're going to wrap up this session and we will be back with another segment in just a moment.